Good afternoon, Commissioners.
Good afternoon, Judge Kgoele. How are you this afternoon?
I am fine, Chief Justice.
You are ready for us?
Yes, I am, Chief
Yes,
Justice.
no, that's good to hear. Thank you very much for availing yourself for consideration for appointment to the Supreme Court of Appeal. I am going to ask you some questions, and after that I will allow the Deputy President of the SCA to ask questions, and the Minister, and any other commissioner who wishes to put questions to you. In asking our questions, we will be seeking to get information that will assist us to see how you fare in terms of the selection criteria that this body has adopted in respect of judicial appointments. We will be seeking to ensure that while we may be robust in asking you questions, we will show courtesy and respect. You are ready for the first question?
Yes, Chief Justice.
Okay, all right. You possess or hold a BProc degree, an LLB, and an LLM, is that correct?
That is correct, Chief Justice.
And you got the BProc and LLB from the University of the North during those years?
That is correct, Chief Justice.
Yeah. And you got your LLM from UNISA?
My LLM and the old LLB in the olden days, it was a separate degree, unlike now, from UNISA.
Oh, the LLB you also got from UNISA?
Yes.
Oh, okay. Was your LLM a coursework LLM or a dissertation LLM?
It was a coursework.
Okay. And what branches of law were covered by the papers that you did?
Constitutional interpretation, advanced law of evidence, and advanced law in criminal law. And the last one was winding up insolvency and estate. There were 4.
Okay. Instead of your, in the case of your entry into the legal profession, did you start as a prosecutor?
Indeed, Chief Justice.
And you moved up to being a magistrate and a senior magistrate, is that right?
Indeed, Chief Justice.
And you also became a regional court magistrate?
Indeed, Chief Justice, although I didn't stay long there in that position, because at the same time, there was that course that was structured to fast-track women to the judiciary. I was fortunate to be nominated to attend one, so at the same time, during that time, I attended the course and I was successful, and after that, I was called to act, and I went to act in the High Court.
Yes. Did you start acting in the High Court in 2018? No, I
think it's
2009. Or 2008?
Yes, I think it's
2008, I think.
Yes, 2008, because my appointment, if I'm not mistaken, I'll check it, was 2009.
November 2009?
Yes.
Yes. So you have been a judge for about, what, 14 years?
No, more than 15 years for now, because my 15-year was end May, because they also included, when they calculate my service, they included the fact that I acted continuously up until I was appointed.
Yes. Okay. You were initially appointed to the Northwest Division of the High Court,
Indeed, Chief Justice.
but recently you went to the Mpumalanga Division, is that right?
Indeed, Chief Justice.
Did you relocate completely, or you just wanted to work in Mpumalanga but retain your home in Northwest?
I retained my home, but I wanted to relocate. Unfortunately, whilst I was still looking for accommodation, COVID hit us, and then I couldn't get accommodation at that particular time. And I don't know whether I should say it's an unfortunate situation also. During that particular time, during the COVID era, I was called at the SCA, and then I couldn't also not get time to get full accommodation, residential accommodation. I'm only back now, and property there is expensive. I'm still looking for it.
You have acted as a Deputy Judge President in Mpumalanga.
Indeed, Chief Justice.
How many acting stints have you had as acting Deputy Judge President?
I had 2 in Mpumalanga and 1 whilst I was still in Northwest.
Yes. Okay. How did you find the leadership role?
It was interesting, demanding at a higher level, because now I was in the High Court. But if you look at my track record, I had been in the leadership role since my early stage.
Yes.
I was appointed a prosecutor, and immediately after 2 years, I was elevated to the bench. Within 1 year, I was requested to head a magistrate office. So I also went to Uppington to head the magistrate office in Uppington. So it was a good experience, challenging, but I didn't find it so difficult because I had previous experience at the lower court.
Yes. And how many acting stints have you had in the Supreme Court of Appeal?
If we calculate it, I think it's 5 terms, because I acted for a complete year, 12 months, and then I was recalled again for 4 months.
Yeah.
From June to September, 4 months. That's another term.
Yes. And how did you find acting in the Supreme Court of Appeal, coming from what are not considered big divisions?
It is on a different level, because the matters there are dealing with issues that are intricate. But at the same time, it is an empowering situation, because unlike in the High Court, in most of the time you sit alone, decide matters alone, but whilst you are at the appellate division, you sit in panels. So it is enriching to oneself, because you have the benefit of the minds of other judges, who mostly are even senior to you, and at least it's enriching. You get to know, or you get to adapt very quickly. So I think it was okay, but when I was acting, it was during the COVID era. We did not have the benefit of like walking into a senior's office or a colleague office to bounce your idea because of COVID. And we did not go to the tea room because also a tea room situation also helps. A lot of the Supreme Court judges worked from home, so there were few. So one has to duck and dive to learn the ropes alone, but because I adapt quickly, I managed. Thank you.
Now, while you were in the Northwest Division, also in Mpumalanga Division, did you get a chance to deal with a matter where the constitutional validity of legislation was challenged?
Yes, but not where I was supposed to have declared it unconstitutional. There were other issues around the Constitution, but not where I was supposed to declare it unconstitutional.
Yes. And in the Supreme Court of Appeal, have you had a chance to deal with such matters?
No.
Yes. Okay. Now, there are two types of discretion in law. Are you familiar with them? And if you are, what is the legal significance between the two?
I think they are the narrow discretion and the wider discretion. If you are on an appeal level, when you find a matter where the issue of discretion comes in, you have to check whether it was a discretion in the narrow sense or in a wider sense. Then, if it is in the narrow sense, then on an appellate division or when sitting as an appeal, you will basically check whether that exercise of discretion was done judicially or not. And the wider discretion, it's more, the test there is more stringent, because then you will have to check whether whatever discretion was exercised is at odds with the law. Thank you.
I will now give the Deputy President of the Supreme Court of Appeal an opportunity to put questions to you.
Thank you, Chief Justice. Good afternoon, Judge Kgoele.
Good afternoon, Deputy President.
In your questionnaire, I want to take you through to paragraph 16.5. You listed 3 reserved judgments. What is the status of those judgments?
I have, at the present moment, delivered all of them. I'll give you the dates, but if you can also check the comments from the General Council of Bar, they have already picked up that of the 3 when they made the comments, I had already delivered 1. But I'm going to update you in terms of the dates. The Matata.
Well, the answer, sorry to interrupt you, Judge Kgoele, the answer is sufficient.
Okay, thank you.
So your last acting stint at the SCA was in
September, I'm sorry if I'm interrupting.
August, September 2022. 22, yes.
Yes.
And you have not been to the Supreme Court of Appeal ever since.
Indeed, Deputy President.
A year ago, you appeared before the JSC, and the proposition that I put to you was that you are not ready to ascend to the bench of the SCA, and that more acting stints would help you perfect your judgment writing skills. But you were not interested in that invitation in the sense that you indicated that you were ready a year ago already.
Indeed, Deputy Chief Justice, I said that.
And what happened between then and now, when you have not had the opportunity to go and act at the SCA again, which makes you believe that you've got what it takes to be a member of that court, bearing in mind that it is a national appellate court which, amongst other things, must give guidance to the High Court insofar as the state of the law is concerned.
Thank you. I was fortunate to be allocated special motions, special trials, and appeals by the JP, the former JP, and the current JP. I think they were trying to tap on the experience that I had when I was coming from the SCA. The special motions are those cases where, in most of the time, the papers filed are voluminous, the issues are intricate, and or where the JP is of the view that the issues are designed to create a precedent in the division. And our division is a very small division. We have few permanent judges. So we operate mostly with fairly recently appointed judges and mostly with acting judges. The upshot of this is that as a senior judge, or as a presider, if I may call that, in those cases, you do more work to be able to steer the issues in those special motions, special trials. Last week I was doing a special appeal. When you sit with them, in addition to that, you also assist them, the junior, in writing their judgment. You oversee them. In fact, you oversee them. So the experience that I had in the SCA managed made me to manage to do that, but at the same time when I was overseeing their judgment, I further honed my skills. The other thing that may count in my favor is that I kept on following up on matters that I dealt with at the SCA, or where I was the scribe, or where I was just a panel member that went to the CC to try and keep abreast with the developments of the law. I can mention one or two: the Minister of Water and Sanitation and others versus Casper. It went to the CC. Fortunately, our decision was upheld. Another one is RISIC, Street One Stop versus RISIC, versus Engine. That one also went to the Concord, but it was overturned. The other one is the Independent Community Pharmacy Association versus Clicks. There was a split majority. It also went to the Concord. There was a split majority. The minority, unfortunately, agreed with our decision. And the majority, overturned us. I am aware of another one, B versus B, but I think the judgment is not yet out, so I can't say anything about that one. And besides that, I also, time and again, when I had chance to look at the judgment in the SCA, I did that so that I keep abreast with the developments of the law.
Thank you. I'll propose to put to you what the major difficulty that the presiders had with the sort of judgments that you produced at the SCA, that they were not concise and underpinned by linear reasoning, focusing on material facts only, and that a lot of work had to be done to produce the final product. What's your response to that?
I'm going to respond. Firstly, I respect that view, but I have two fundamental flaws with the view. The first one is that this view only erupts during the interviews, because no presider ever approached me to complain about my judgments during my acting stint. The second is that the criticism is couched in general terms. There are no specifics provided in respect of which judgments are they, and there are no supporting materials to that. Unfortunately, general comments with no specifics are normally aimed at just breaking a person and not building one. Because if the specifics are provided, those specifics will guide you where your flaws are, so that you can be a better person tomorrow. But having said that, the first part of my answer is that it remains the same as last year. I do not agree with the views as so expressed, because no judgment that I wrote were ever taken from me by the presiders. No presider ever suspected, or not suspected, I'm sorry, suggested that a colleague or on a panel should co-write with me. No member of the panel or the presider himself insisted on writing a concurring judgment because of my inability in writing. I'm talking about this because all of these are the trends that we meet at the SCA across if your judgments are not as scholarly as they normally say in this SCA. But I have to also emphasize that writing a judgment is a lifelong learning experience. Even retired constitutional court judges, when they train us writing judgments, they always say that your first judgment will not always be the same as your last judgment, because it keeps on changing as you fine-tune it. But it even becomes worse when you are at the Supreme Court or a court like the Supreme Court, because there, your judgments, you are not sitting alone there. You're sitting with other members of the court. So the judgment is not yours. The judgment is a concocted effort of all the colleagues with their inputs. As and when they make inputs, you accept them. And maybe because, I'm just worried because this issue comes back for the second time. I just hope you are going to give me time to deal with it. I have to give an example. In one of the judgments that I wrote regarding the issues of servitude, in my first draft, I included the principle that we normally call the Kgoele model principle, which I applied to the facts. Now, the presider, when I handed in the first draft, he suggested that I should take everything that related to that. Although I felt strongly against that, but I then said, he's a senior, I think he knows better than me, I agreed. But here is what happened. Normally after the inputs of other colleagues, at the SCA, there is what we called a conferencing. We conference around the judgment, meaning we finally look at it, the final little, we use a fine-tooth comb to just check whether there is anything, but we are all together. So one of the senior judges, whom I regard as a specialist in servitude, was more worried about the fact that I did not include the Kgoele model principles, and he wanted to, to get chance to add that. But fortunately, because I had already done that, but because I was told to take them out, I then said, no, don't worry, look at what I initially said around that. He did that, and after I did that, I reinserted them into the judgment. But I'm trying to say that your first draft to not look the same as the last draft, it is not a surprising phenomenon. And I'm also trying to say that it is not true that my judgment were just hopeless. You always have to try and accommodate the inputs of the others. But assuming that the report that I get now, which is not written, and again for me to lay this matter to rest, I want to say the following. It is important to have regard to the comments that were made by GCB this time. And we don't forget that GCB is one of the reputable legal body which consists of senior council members in it. They demonstrated that they took these interviews seriously, because what they did, on my part, they wrote comprehensive comments about each and every question that is supposed to be answered in the questionnaire. But of particular importance and relevance to the issue at hand is that they also demonstrated that they read my judgments, not only those ones that I have attached, but my judgments on SAFLI when preparing their comments. But again, as I've already indicated, more importantly, that they also read the judgments that I wrote after I acted at the SCA. But they say the following.
Do you still have more to
Yes.
say?
Yes. Chief Justice, I allow indulgence. This is the main issue, I think, that is on the table.
Yeah.
Yes. The candidate in paragraph 9.1, the candidate has produced well-structured and clearly written judgment penned in English. And in one of the paragraphs, they also said they randomly picked my judgments. And I can also give credit to the comments that were made by LSSA, the Law Society of South Africa. Because there they say, in one of their judgments, her numerous judgments are well written and incisive. I think by choosing the word, and they said numerous, it means that they not only look at the SCA judgment, but those that I wrote at the High Court as well. But in my view, the word incisive, it's very important. And when I looked at the dictionary word of incisive, it says it means intelligently, analytically, and clear thinking, which is contrary to the views. But if we relate that definition to the action of a person, in particular in writing, it means that the ability to express what you intend clearly and quickly and directly. I am of the view that the selection of these words is instructive. I do not think that they just chose to include these sentences without having read my judgment. Thank you.
Thank you, Judge Kgoele. But you would accept that the GCB would have had a recourse only to the final judgment that was delivered by the court.
I'm not sure whether I should answer because I saw, okay, sorry. The final judgment, if I understand you, pardon me if I don't understand you, by the court or by myself, yes. The final judgment, I indicated that they not only looked at the SCA judgment, I said they also looked at the judgment that I produced alone. Yes, they looked at that, my final product. And as far as the SCA judgments are concerned, yes, they did look at the final product. But as I said, the final product might not even look like the first one, which is normal. The first draft that you made, because you make room for inputs of other judges.
And therein lies the rub, because if you accept, as you do, that the final judgment bears legal resemblance to what was initially produced by you before the inputs of the other members of the panel.
Okay, if I may answer, I did not use the word little resemblance. I said it will not look exactly the same. So the word little has another meaning.
Thank you. Let's go to paragraph 16.1 of the questionnaire. It asks you to list judgments that you consider as significant and why. And you have listed those judgments on pages, paginated page 16, 17, 18, 19, 20. And I've had a look at those judgments in preparation for this interview. And in my view, they do not appear to have any precedential value. No new principle, no departure from an established principle, resolving, uncontentious issues, well precedented. What's your response to the proposition that I'm putting to you?
Deputy President, I respectfully respect your view, and that is your view. It will remain your view. But if we go back to the very same paragraph that you referred me to, paragraph 16.1, I'm going to repeat. It says, list the cases where you have written the judgment which you, meaning myself, it's relative, which you regard as being the most significant. Not necessarily setting precedent, but significant. And you have to, to state the reason.
Yes.
In all those judgments, I summarize what they are and why I personally regard them as significant. There's no one that I did not give reasons. If I can go to the annexure. The first one, Leon Geraldine versus Leakey. I said the matter, its significance because it demonstrates that sexual intercourse by an adult with a child will not be tolerated irrespective of whether the perpetrator is a female person. And the custodial sentence was confirmed by this judgment, was endorsed. That is my personal view, but another view which might add on what I said is that this matter has been reported. If it is reported, it means it meets the characteristics that you have just enumerated, or one of them, Deputy President. The Sajwa matter also, previously I also indicated that it went to the Supreme Court of Appeal, I think, on petition. It even went up to the Concord and it was confirmed. But there I also, my view was that it is important because it demonstrated that where there were two distinct decisions which remains valid until set aside, they will remain valid until set aside, and one, you can declare one and not the other. And on this one, when I dealt with this matter, I struggled to get a case similar to that one. In my view, even if it is not reported, it was very significant and it could have been a precedent setting. Brightwater as well, I'm not sure whether I should go one by one, but the reasons are there.
Yeah, well, you
Maybe
can,
to same time.
You can work on the basis that the commissioners are familiar with
They
your
read,
material.
they read.
Yeah.
That. Thank you so much.
I hope you do appreciate, Judge Kgoele, that I'm here to represent the interests of the court. And my involvement here is not about me or you.
I don't understand, Deputy President. Maybe you can elaborate further.
That I'm representing the SCA.
Yes, that I know.
Yes.
Yes.
And I'm duty-bound to put to all the candidates the difficulties that colleagues at the SCA had with each one of the candidates that will be interviewed during the session.
I fully appreciate and I know that because I'm not coming to the interviews for the first time.
Thank you.
Yes.
We'll then leave it on that note. Thank you, Judge Kgoele, and
Thank you,
Chief Justice.
Thank you, Deputy President.
Thank you, Minister. No questions. Commissioner Nochesi, and then it will be Commissioner Baloyi. I'm sorry.
Thank you.
I'm sorry. Commissioner Marmohai. Before Nochesi.
Thank you very much, Chief Justice. Good afternoon, Judge Kgoele.
Good afternoon, Commissioner.
I have two questions for you. The first one is, assuming that you are successful and you are at the SCA, and you happen to be one of the two judges that considers an application for special leave to appeal. And you find that you allow the matter to, you uphold the appeal. But you say, look, maybe it was a matter that can actually be dealt with by the full court. And then you say, no, we are not going to deal with it as the SCA, and we are going to take it back to the full court. Perhaps maybe the appeal was from the single judge sitting at the High Court. Under those circumstances, when the parties are going back to the High Court, given that there's a specific rule that deals with security of costs at the High Court, is the person who is successful at the SCA under those circumstances bound to pay security for costs? I'm not sure if you are with me.
Security for cost for the matter that has been at the
Yes, for the appeal that has been granted by the SCA. But the SCA has said, look, this appeal should be dealt with by the full court of the High Court.
Yeah, maybe I need more clarification because
let me try to
initially-
clarify it. Let me try to clarify
Okay,
it.
yeah.
You have a judgment of a single judge in the High Court. Let's say maybe the single judge dismisses leave to appeal. Then the party who lost appeals or makes an application for special leave to appeal to the Supreme Court of Appeal to be allowed to appeal that decision. And the Supreme Court of Appeal says, yes, you can do that, but we are not going to consider it. Go back to the High Court. So normally, when you appeal from the single court to the full court, there is a provision that says you need to pay security for costs.
That is
So
where
what I want to understand is, when the judgment comes from the SCA, is there an obligation to pay security for costs?
In my view, I don't think so because, and that is where we couldn't get each other because I was going to say, remember before it goes there, security of course will have been paid. Yes, so when it comes back, I don't think there's an obligation as such. That's my view.
All right. No, thank you very much, Judge Kgoele. The second question that I have is, and I think, look, I've read your judgment since from your days in Mafikeng to now in Mpumalanga. I think you write well. That is just my view. I think you do write well, contrary to some of the judges who express concerns at the SCA. I think your judgments are well written. That is just my view on that.
Thank you very much. It will make me feel better. Because,
you contributed to two judgments in the SCA. The one is the ACAS matter. I'm not sure if I'm pronouncing it correctly.
Yes.
And the other one is B versus B. Both of them were maintenance issues. I just want to talk to you about the B versus B matter, where you enjoyed the majority. I mean, you wrote a unanimous judgment in that court. Basically, the facts were, or part of the facts were, you were dealing with an NCA, ANC, and on the other hand, there was an agreement. I'm particularly interested in paragraph. I know you may not have the judgment with you now, but I just want to make a point because this is not necessarily a test. In one of the paragraphs, you state that the ANC is by no means a contract. I was perhaps maybe I did not understand the context of that. And it's a pity that you don't have that in front of you. I just want to understand your understanding of an anti-nuptial contract and how an anti-nuptial contract should regulate the marriage in the context where there is an alternative or another agreement that the parties have actually signed. Because that was the main issue in this judgment. Which contract becomes, or which document becomes an important document for the regulation of the parties' matrimonial property system?
Expressing my view, not necessarily, but I will look at which sentence were you saying. I'm not sure whether we say an ANC.
It's in paragraph 8.
Paragraph 8. It's not a contract. Let me just check the context. Is it B versus B?
Yes, B versus B.
Yes.
Paragraph 8, line number 3 from the top, the second sentence in that paragraph. It contains footnote 3.
Or footnote 3.
Yeah,
Are
but
you saying paragraph 8, which start with it is instructive?
Yes.
And then line number 3.
Line number 3, sentence number 2, which starts with regarded in this slide.
Sorry. Regarded in this slide, the NC is by no means a contract. We refer to LOSA, South African law. I cannot remember well why we wrote it like that, but maybe it was in the context of.
Or perhaps let me assist you. Is the ANC a contract? Let's start there.
It is because it regulates the what.
No, thank you very much. We can leave it at that.
Oh,
Thank you very much,
Sorry,
CJ.
sorry.
Thank you. Commissioner Nochesi.
Thank you, CJ. That mine should have been a follow-up to the discussion between you and the Deputy Judge President. Firstly, I'm troubled about the fact that there are these presiding officers. Do you know who are they?
Pardon?
I'm troubled by the fact that reference is made to some presiding officers who suggest that your writing is not up to standard. Do you know who are the presiding officers that makes those remarks?
That is the point, because when I talk about specifics, amongst others, I didn't want to prolong the issues. Amongst others, and that is why I said which judgments. I don't have them now. Even previously, I don't have the name of the presiders, and in my view, if they are there, I don't think they are all, if ever they are there, because I receive praises from many of them. Yes.
And now, I asked the question.
And it doesn't assist me, because even for preparation, how do you prepare when you don't have specifics?
Okay, no, it's fine, that's the answer. Now, I asked you the question that I have asked other candidates. At the SCA, you sit as panel, that is as a panel, and one would be assigned as a scribe. Is it something unusual or unexpected that other members of the panel would contribute to the judgment that have been produced by the scribe, would comment and contribute in that judgment? Is that unusual? Is that unacceptable?
It is not unusual, and it is what makes the judgment a judgment of the court. They are supposed to comment, and fortunately, as acting judges, we are even empowered by that.
Yes. And lastly, are the presiding officers equals among other equals in the panel, or they perform some function similar to that of a principal in a school who correct script?
They are an equal amongst equal, but for you to be nominated as a presider, it's because of your experience and leadership. You are not supposed to be there like an umpire, or like you are saying a school principal who says this is right, this is wrong, and all those kind of things. One of the duties that I have, that is my view, I'm not sure because I come from a leadership point of view, is that they are supposed to empower or guide us there.
Thank you very much. Commissioner Baloyi.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
Yes,
I can't see where you are. Oh, yeah.
I'm here. Yes, Judge, in the application form where you list the cases that you the first question is 16.1 that you consider to be significant and why. And then there's judgments that have been upheld and judgments that have been successfully appealed. Now, in this long list of judgments, I have identified only one judgment, and please correct me if I'm wrong, which is written by you, not written for the court. It's a mix of, the rest of them are a mix of a full bench in the Northwest Province, or you sitting with another judge, Judge Kgoele in some instances, and somebody else as an appeal court. And then you've got the SCA judgments where you were either a scribe or you were part of that bench. Now, it's very difficult from these. In fact, it's impossible from this. The one that I've identified as your judgment is the Bishop judgment that was successfully appealed. Now, from these court judgments, one doesn't have a way of evaluating your judgments, and this is especially important in the light of, whether fairly or unfairly, in the light of your early discussion with the Deputy President, the kind of comments you have received. Now, when one doesn't have any judgments that were written by you, it's very difficult to evaluate your ability to write judgments. What do you say? And I feel disadvantaged completely to make any comment about your judgments.
Are you referring to the judgments that I attach if I want to understand?
That you have listed. You have listed in 16.1.
Okay.
You have listed what you say are significant judgments, and there's that debate about what is really significant about these judgments. But you have listed those judgments. Now, 16.1, you've referred us to an annexure, and those judgments in the annexure are judgments that you wrote for a court. And then 16.2, the judgments there, the first one, Sheldon Lakey, is a judgment, it's an appeal.
I wrote, but for the court, yes.
Yes, and the balance of them are SCA judgments that are reflective of, I'll call it a committee judgment, and the same with all the rest of them.
Yes.
So before us here, do you accept at least that before us here, except for the Bishop judgment, where the SCA found you were wrong, except for that, we don't have before us judgments that are your judgment, not the court's judgment. That's what I'm checking with you.
It might be so, but the last part of your question, you said you might not be able to assess the quality of my judgment as stemming from the discussion with my Deputy President. I don't think that can be the case because, remember, judgments now are reported on SAFLI, all of our judgments. Each and every judgment that they are reported on SAFLI. So, and other what is it? Other platforms. So, like the GCP did, they did not just look at what I produced. They went there to check. And then that is why they are able to say what they said about me, about my writing skills.
Yes, can I put this proposition to you that you've given us judgments that you say we should look at, because you choose the judgments that we should look at. So can I, if please allow me to finish?
Yes.
Thank you. You have listed for us the judgments that you say we should look at, right? And we've gone to look at them. That's why this engagement is able to happen. And it's disappointing that from reading these judgments, one can't say anything about your writing judgments. And so when there's a comment like that, one does not have a way of evaluating it against the objective material that is here. But to comment about the GCB, it's also not helpful because the GCB doesn't say what judgments they have looked at that you say they have independently sourced or randomly sourced. They just make the statement, and I think you read it one way and I read that statement differently, but I'm not engaging with that. What I'm saying is, well, it's not even a guide from the GCB to this panel, at least, to say, go look at this judgment. This is the one that she's written. In fact, I think what they have done is to, in the summaries that they've given, is to include those judgments that I'm talking about, where you were writing with others.
Thank you. But remember, when you are answering, you are guided by the question. The question says that you wrote and that you feel are significant. So this time, the question was not necessarily about the issue that is on the table, my writing skill as such. I think the key word, I looked at the issue of significance to me. Thank you.
CJ, if I could just follow up on that last part. Yes.
Yes.
And maybe on that last part where you talk about significance, I mean, looking at the Sheldon Lakey judgment, you say now in the application that it's significant because it makes the point that a woman will not be treated any more sympathetically compared to a man committing the same crime. But there's nothing like that in the judgment itself. You have read the judgment and you speak to the general principles that apply to cases like this. There's nothing distinguishing in it, and you at least not in the body of the judgment. But I'm not even sure about that. I know I don't agree with your saying it's important because it shows that a woman will not be treated any differently. Well, the law doesn't distinguish. You know, you have sexual intercourse with a minor, there are consequences. It doesn't matter who you are. And so it's not even clear to me, why do you even say this is significant, especially you don't say anything about that in the judgment?
I've got two answers. The first one is that for a judgment to be significant, it does not necessarily mean that we should write that in the body. You look at the judgment as a whole and get the significance thereof in the judgment as a whole. And two, even now, if you can look at it, and that is why I said it is reported, and the reporters saw it very important that it should be reported, because there is a custodial sentence, if you can look at it, and this type of offenses are not, they are rare. I haven't read of any other, matter of this sort since then, to be honest. So it was significant to, and also to emphasize the fact that we don't differentiate a wrong because it was committed by a man or a woman. A wrong is a wrong. Thank you.
Thank you, CJ.
Thank you, Commissioner. Commissioner Steinberg.
Thank you, CJ. I'm here.
Yes, thank you, Commissioner.
Good afternoon. My one question is adequately covered by Commissioner Beloy, so I'm not going to go there. The second, I'd like your comment on something. I was specifically contacted by colleagues who commended you in a full bench appeal in which you were the presiding officer, I think about a week ago, concerning the execution of an order in terms of Section 18.3 of the Superior Court Act that involved ESCOM and another party, that you quickly and confidently saw the issue with the finding of the court below. You put it squarely to the parties,
Yes.
and you then handed down your order immediately, knowing what the urgency of the matter was. Perhaps you can just tell us a little bit about that test and how you applied it and what the problem with the acting judge in the court below was.
Yeah, that was the agenda appeal last week. But I'm not sure whether, I'll briefly comment because they indicated that they want to appeal that decision, but I saw that there is a recent judgment already in the Supreme Court of Appeal which says that they don't have a second bite of the cherry. They cannot appeal further. So let's put that aside. But I just wanted to say to you that I won't go into details because they seems to want to appeal so they can exercise it, whether they will be rightly received or not. That's another thing, or another debate for another day. But the trial, the judge there, I think there were several flaws, but we concentrated, I wanted us to concentrate mostly on the requirements, which are firstly whether there are exceptional circumstances, and secondly, there are two very important requirements. One, whether the applicant will suffer prejudice if the order is not implemented. Now, the second leg, the third one, whether the respondent will suffer prejudice. Now, I think the Kodako made a mistake there because instead it weighed or balanced these two requirements instead of treating them as distinct requirements. Because there's case law here. We have a case of Justice Wallis, as he then was, which says when you check whether there's prejudice or when you deal with the requirement of the prejudice of the applicant versus the prejudice of the respondent, you don't balance. But you look at whether there's prejudice for the applicant and also look whether there is or will be not prejudice for the applicant. So the court, accordingly, didn't do it right. They put it in the pot and sort of balance them, which is not right according to the law that I read. But then the other problem was the test there. The test there is not, it's the test on a balance of probability. And the onus rests upon the applicant. The applicant must satisfy the court that deals with Section 18(3)(1) that the applicant will not suffer prejudice, will suffer prejudice. And two, which is important, and that's where the court committed a material error. One, that the applicant must also prove that third leg, the third leg being that the respondent will not suffer prejudice. So the applicant in that matter wanted the respondent to prove that, which is not what he's supposed to do or what the law says. And unfortunately, the judge fell for that. Thank you.
Thank you. JP.
After the JP.
Oh, JP. Thank you. Commissioner Ngwetobi.
Judge, I'm trying to get a sense of to follow up on Commissioner Baloyi's point, trying to get a sense of this problem that she can't understand your actual legal reasoning from the judgments you've submitted, etc. But maybe I can understand it from the perspective of just having a conversation. There was a question asked by the Chief Justice about the different types of discretion. You remember that it was right at the beginning.
Yes, Commissioner.
Yes.
Sorry for
Now,
that.
I don't remember that you answered that sufficiently. Now, I don't want to go into a discussion about your candidature if, in fact, you know the answers, but maybe you were under pressure and not expressing it fully. So there is the narrow discretion, and then there is the wide discretion, correct?
Indeed.
Yes. And the problem is that you moved into what an appeal court should do when confronted with a narrow discretion without first describing what a narrow discretion is. You remember the famous or infamous dictum of Porter Stewart, a judge of the Supreme Court in America, when asked what is pornography. Well, I don't know it, but I know it when I see it. So I
Yes.
don't. So it seems we must first understand what it is that we're talking about before talking about what an appeal court should or should not do with it. So can you just explain what is a narrow discretion, what is a wide discretion?
Sure. That's not an easy answer, the question.
I mean, and how do you
Yeah, and-
know that you are dealing with, you've got a statute or you've got a rule or regulation. How do you know that here I'm dealing with a narrow discretion and here I'm dealing with a wide discretion? What are the features or the characteristics?
The features of a narrow discretion is where, if I can explain it, where you can see that the discretion is, in a narrow sense, it is, and not, it should not be sort of unfettered with. A wider one.
But what does that actually mean? I mean, this is all from decided judgments. Trencon is the main one from the Constitutional Court.
Yes, but I was going to say, we do that, we are able to do that in terms of what the courts or the Concord had decided. We take precedence from how they
No, I accept
describe.
that. I just want to know, just give me just a short understanding. A narrow discretion is where X, Y, Z. A wide discretion is where X, Y, Z. That's really what I'm looking at.
Yeah, that's a difficult one. I cannot just do it immediately like that now, unfortunately.
Thanks, Chief Justice.
Thank you. As I think we are about to finish to end the interview, did you enjoy your time in the SA while acting there?
Indeed, Chief Justice.
Yes. The atmosphere was good.
Yes.
Okay. No, thank you very much. There are no further indications of questions. Thank you once again for availing yourself. We appreciate it very much. You are now excused.
Thank you very much to all the commissioners.